Anti-Defection Law latest news. Recently, 7 of AAP's 10 Rajya Sabha members, including Raghav Chadha, who had been removed as the party's deputy leader in the upper house just weeks prior, announced their merger with the BJP. This development has reignited a long-standing constitutional debate around the 10th schedule of the Indian Constitution, popularly known as the Anti-Defection Law. The Anti-Defection Law, enshrined through the 52nd Constitutional Amendment Act, 1985, the 10th schedule was enacted to curb floor-crossing, the practice of elected representatives switching parties for personal or political gain. A legislator faces disqualification if they voluntarily relinquish membership of the party on whose ticket they were elected, or vote or abstain from voting against the directions of their party or authorized functionary. 2 exceptions to disqualification under the Anti-Defection Law. The split exception, paragraph 3, protected legislators from disqualification if at least 1/3 of the legislature party defected together. This was removed by the 91st Constitutional Amendment, 2003, owing to its systematic misuse to engineer defections. The merger exception, paragraph 4, still in force. This protects legislators who join another party as part of a genuine merger of their original party. 2 subparagraphs govern this. Paragraph 4, 1. A member is protected if the original political party merges with another. Paragraph 4, 2. Such a merger is valid only if at least 2/3 of the legislature party consents to this merger. Significance of exceptions. The exception was intended, as reflected in parliamentary debates, to protect principled defections rooted in ideological differences. The legal ambiguity. The crux of the current controversy lies in how paragraph 4's 2 subparagraphs are interpreted. Conjunctive vs. disjunctive reading. Conjunctive, both a national-level merger of the original party and 2/3 consent of the legislature party are required. Disjunctive, a deemed merger is triggered by 2/3 consent alone, even without a formal merger at the national party level. Judicial precedents. Rajendra Singh Rana v. Swami Prasad Maurya, 2007. The Supreme Court, while interpreting the now-deleted split exception, endorsed a conjunctive reading. It held that a split in the legislature party must stem from a corresponding split in the original political party. Goa Congress merger case, 2019 to 2022. 10 Congress MLAs in Goa joined the BJP, claiming they constituted 2/3 of the 15-member Congress legislature party. The Speaker upheld the merger. The Bombay High Court, February 2022, affirmed this, adopting a disjunctive reading. It ruled that a deemed merger occurs once 2/3 of a legislature party agrees to join another, without requiring national-level party approval. Expert opinions. P.D.T. Achari, former Lok Sabha Secretary General, conjunctive view. A valid merger requires the original party to first merge at the national level, followed by 2/3 support from the legislature party. In the AAP case, this would necessitate Arvind Kejriwal's consent to a merger with the BJP. He noted that any member may now file a disqualification petition before the Rajya Sabha chairman, whose ruling would be subject to judicial review. The Center for Legal Policy disjunctive view with caveats. The 2/3 threshold being met could allow the move to qualify as a deemed merger. However, he flagged a deeper anomaly. Rajya Sabha MPs are elected by state MLAs, and the AAP MLAs in Punjab who elected these members continue to belong to AAP. This creates a disconnect between the electoral base and party affiliation of the MPs, undermining the very logic of Rajya Sabha representation. Challenges. Ambiguous drafting. For example, paragraph 4 leaves room for contradictory judicial interpretations, which could be misused to legitimize opportunistic defections dressed up as mergers. Absence of the split exception post-2003, this means there is no explicit provision for partial defections, making the merger route the only legal pathway. Structural anomaly. MPs switch parties while the MLAs who elected them remain in the original party, weakening the principle of representative accountability. The Rajya Sabha chairman, as the adjudicating authority, may face questions of political impartiality. Way forward. Definitive ruling. The Supreme Court needs to end interpretive uncertainty on the conjunctive versus disjunctive reading of paragraph 4. Legislative clarification, through a fresh constitutional amendment that explicitly defines the conditions for a valid merger. Structural reforms. Strengthening the independence of the presiding officer, speaker/chairman, in adjudicating disqualification petitions or vesting such powers in an independent tribunal. This has been a long-standing reform recommendation of the Election Commission, the Dinesh Goswami Committee, 1990, and the Law Commission's 170th Report, 1999. Conclusion. The AAP Rajya Sabha episode is not merely a political event, it is a constitutional stress test. It exposes the unresolved tension at the heart of the 10th schedule, whether the merger exception is a safeguard for principled ideological realignment or a loophole enabling opportunistic party switching. The case is ripe for Supreme Court adjudication and legislative clarification. Until then, India's anti-defection framework remains vulnerable to the very malaise it was designed to cure.